State of Madras 1950, SCR 5 and 94, State of Bihar Starfi, Shailahala D1I, L952J, SCR 65 LJCH, B New York 198 US 45, State of Madras VVGR 1952 SCR 597, Foint Anti-Fascist Fuji Komitevmi, Grai J 341, TS 123, Munichi NLE Committee V. The State of Punjab 1969, 3 SCR 4714, Collator of Systems, Sampathu 1922, 3 SCR 786, 800% ABQZ Vuni India 1971, 2 SCR 4 Waimbaransi 470, Kwamhi VS Farzon 41 T of BHLNR 1959 and J, SCR, Namthi V, State of M11 RS Lialvenra, 1986, 3 SCR 744, CV Til, Sinarag Shantunshadan, J1, 442, 447, referred TD. Thus, there were no oppressed or implied limitations upon the poor a parliament to amend the fundamental rights in such a YUTD. Or damage the core or essence of the repute to be 24th, 8 Kesavananda Bharati, Matthew J. Y. 65. Its language makes it clear beyond doubt. The majority decision in the Golaknath case negatived the constituent power of the Parliament to amend the fundamental rights in such a way as to take away or abridge them, which, according to the amending body, was wrong. The amending body passed the amendment to make it clear that the power to amend is located in the article, that it is a constituent power, and not a legislative power as held by the majority decision in the Golaknath case, that the power is plenary in character, and that Article 13(2) is not a bar to the amendment of the fundamental rights in such a way as to take away or abridge them under Article 368, that the object of the amendment was declaratory in character, is clear from the statement of objects and reasons for the amendment. An amending body can, in the exercise of its power to amend, if the power to amend is plenary, make an amendment in order to make clear what was implicit in the article and correct a judicial error in the interpretation of the article. P. 836, 837. Even if it be assumed that the actual power for amendment under the RT.Lay was limited, the article gave the amending body a potential power to conlarp or contract the limit of the actual power. The potential power, when x1 size, e by the amending body, makes the actual power either enlarged or contracted, P. 837. The word amount in Article 31(2), as amended by Constitution 25th Amendment, does not convey the idea of TLFLJ norm. The fixation of the amuna for the principle for determining the amum is 11 matter within the absolute discretion of the parfumant, or the state LGI1 Latwes. The court cannot go into the question whether the amount fixed by law or the PRFN cycle laid down for determining the amount is adequate m relevant peer forhimeg. It is a mistake to speak of property as JF. It were an institution having a fixed content constantly remaining the same, whereas in reality it has assumed most diverse forms and is still susceptible to great unforeseen modifications. It is necessary to distinguish at least 3 forms at private property, i.e. property in durable and non-durable consumer goods, i.e. property in the mean of production worked by their owners, and thrani property, with means of production not worked or directly managed the hours, especially the accumulations of masses of property of this kind in the band of a relatively narrow class. While the first 2 forms of property can be justified as necessary conditios of a free and purposeful life, the third mawandruar. For this type of property hive, power not only over thing but through tidanin, exovu PC nunsit is open IO. The charge made that any form of property we gives man power over now is not an instrument of freedom, but of servitude. AJY defense of the right to own and hold property must essentially be the defense of a WCLJ distributed property, and not an abstract right that can in practice be exercised only by the few. PO 40, 841. When property is acquired for implementing the directive principles under Article 39B or 39C, is there an ethical obligation upon the state to pay TLTE full market value? AJL adequate theory of social justice should enable 1T. The whole purpose of the amendment is to exclude judicial review of the question. Whether the amount fixed or the principle laid down by law is adequate or relevant, fixation of the amount or the laying clown of the principles for fixing it is left to the absolute discretion of the Parliament or the Stow. Legislatures, thesis of conede, atis of social justice. And the principle of social justice will not furnish one would wondly manageable est wonders either for testing the adequacy of the amount on the n lev mc of the principle, pi 42 to 846 s 36 sc India. 7166 Supreme Court reports, 1973 sub PSCR. His Lordship did not find it necessary to go into the question whether a law fixing an amount which is illusory or which is a fraud on the Constitution can be struck down by court emperor. The declaration visualized by